Good evening, Mr. Ronaansen.
Good evening, Acting Chief Justice.
How are you this evening?
I'm very well, thank you, and thank you for all of you being so patient.
Thank you. I think we might have to close here because it's noisy, it's drowning the voices. Thank you for coming to this session of the Commission's interviews, Mr. Ronaansen.
Thank you. It's my honor to be here.
And thank you for availing yourself for consideration for possible appointment as a judge of the Eastern Cape Division of the High Court.
That too is my honor, sir.
I see that in terms of the questionnaire, you hold the degrees of BA and LLB, which you got from Stellenbosch University.
That is correct, Acting
correct?
Chief Justice.
You got your BA in 1977 and your LLB in 1979.
That is correct, sir.
Yes, and you started your legal career as a public prosecutor.
That is correct. Yeah.
That was in 1980. Is that right?
Yes, that's correct.
January 1980.
Yes, in Stellenbosch as well.
Yes, and you also served articles and you were admitted as an attorney?
Yes, I was admitted as an attorney in 1985, Acting Chief Justice.
Yes, and did you practice as an attorney for 2 or 3 years before you went to do pupillage?
That is correct. I practiced in Pretoria for 3 years at an intellectual property firm.
And you started practicing as an advocate from July 1988?
That is correct. I did my pupillage in the first half of 1988 in now Gqeberha, and I commenced in July 1988.
But did you later go back to being an attorney with a law firm called Spilkin and Mills?
That is correct, Acting Chief Justice. They made me an offer which I thought was attractive at the time, and I spent approximately six and a half years there. Yes.
Yes, and then in January 1999 you went back to the bar.
That is correct. Where I've been ever since.
And you have been practicing as an advocate since then without interruption up to now.
That is correct, Acting Chief Justice.
Yes, and that makes it a period of about what, 21 years?
22 years.
22 years. Okay. And are you able to share with the commissioners the types of cases that you were exposed to in your practice as an attorney first and in your practice as an advocate over all these years in terms of different branches of law?
Yes. Acting Chief Justice, my initial exposure as an attorney was at an intellectual property firm where I worked in the copyright and trademark department and got quite a large exposure to litigation in that field, particularly unlawful competition litigation and trademark infringement litigation. I've limited exposure to patent infringement litigation, but mostly in the field of trademark and copyright. When I commenced at the bar, I initially did some criminal work. In the mid to late 80s, the Eastern Cape, as most of the country, was beset with the criminal case. Political cases dominated the criminal role in the then Supreme Court, and I was involved in some of those defences. Those defences were sponsored by philanthropic organisations from abroad, but eventually my work, I didn't do any more criminal work, and my speciality was commercial work. It's always been my passion, and cut my teeth in the magistrates court with civil trials in the magistrates court, and at the same time developed a substantial motion court practice in the High Court. Acting Chief Justice. And eventually, my practice has also developed to include a substantial amount of work in the field of administrative law and some constitutional law, which I find particularly exhilarating work.
Yes. And did you take silk in February 2016?
That is correct, Acting Chief Justice.
Yes. And in terms of cases that you have handled in the different courts, there would be cases that have been reported that you had argued, is that correct?
That is correct, Acting Chief Justice.
And you have set them out in the questionnaire?
Yes, I have done so.
Yes. And you have also acted as a judge in the High Court?
Yes, I have done so for 3 full terms.
Yes.
The second term in 2019 and the second and third terms in 2020.
Yes.
A total of, I calculated 30 weeks by my calculation.
Yes. And did you sit in criminal trials apart from civil trials and motion court?
Yes, I sat in totally in two criminal trials in Gqeberha and one in Makanda. One in Makanda didn't progress very far, and the accused were referred for examination, medical examination. And but I sat in 2 criminal trials. One was a particularly lengthy one, which I only completed. I still have to go back to do the sentencing phase of that trial. I completed that in September of this year. It ran in fits and starts. It was great. We had great difficulty with COVID and other technical problems to complete the trial, but it was eventually completed.
Yes. Judge President.
Thank you very much, ACJ. Good morning, Advocate Ronaansen.
Good evening, Judge President.
Maybe I should start off by saying that, well, as I did with Advocate Malins, that when I approached you and him and Advocate Bieneke, when I was noticing that we were losing high quality judges and inviting you to act in my division, one of the things that I mentioned to you was the fact that you need to subscribe to the view or the school of having baby juniors with you. Now, I've received good reports from black female advocates in particular. They sing your praises in that regard. They say you go all out. You always ensure that you have a baby junior with you. For those who may not know what it entails, one of the consequences is that you must share a fee. Will you confirm that?
Yes, if I may elaborate a bit on that, Judge President, what is unique? I believe it is unique to the Eastern Cape, and I was party to getting that going in the Eastern Cape as a member of the Bar Council was what we call a mentoring, junior senior mentoring program, where we felt that deviling in exposing young black practitioners to deviling work was not sufficient to give them the exposure they needed to first establish sustainable practice and to introduce them to attorneys who had traditionally not briefed a black counsel.
Yes.
So the junior senior mentoring program was established where, in terms of which, beyond deviling, black baby juniors were appointed, and they were in that manner they were introduced to practitioners who traditionally had not briefed black juniors, and that was the start of a very successful, and that program continues to be very successful today. I think my colleague Michelle Bieneke alluded to that as well in her interview today, is how successful that is working. And to answer your question, yes, that does involve giving up a portion of your fee as the senior, but the benefits that it has brought to the junior bar, and particularly black females there, to the extent that some of them have developed into outstandingly good counsel, have developed outstandingly good drafting skills and so on, and are now getting the work independently of the mentoring system. And I might add that for the rest of this year, I have a number of substantial matters, including one in the Supreme Court of Appeal, and in all of them, my juniors are African females.
Thank you very much. At pages 31 to 34 of the document serving before you, headed list of judgments by Eastern Cape candidates, JSC, October 2021. When you get to page 31, you will find that it sets out all the judgments you penned during your acting stints.
That is correct, Judge President.
You never acted before my era.
No.
Yes.
Gratefully, you were the first to appoint me.
21 opposed application judgments were penned.
That is correct.
21, yes. And then 3 civil trials were run and judgments were produced there. Criminal trials 2, criminal appeals 3, civil appeals 7, review of taxation 1. You confirm that?
That is correct, Judge President.
And you are fair with the notion of case flow management?
Absolutely, Judge President. I am a great proponent of case flow management, and its introduction in the Eastern Cape has reaped rich rewards as far as I'm concerned, particularly for litigants who needed their cases come to court sooner rather than later.
Yes.
You were aware that I assisted you with a short note or memorandum.
Yes, I'm actually getting the counsel. Maybe let's view it from this perspective. When I became judge president, let's start off with Grahamstown. Would you confirm that there was a resistance of case flow management in Grahamstown?
I would confirm that.
Yes,
Judge President.
And in fact, I had to introduce it in Port Elizabeth first.
That is,
and then once it started working there, and then it was easier for me to bring it to Grahamstown.
That is my recollection, yes, Judge President.
You penned a letter as chairperson of the Eastern Cape Society of Advocates not so long ago.
Yes.
In that letter, you do not only applaud case flow management, but you also point to certain weaknesses in the system that need beefing up. And I wish to place that on record and want to say I appreciate that greatly.
I'm glad if that could have been of assistance to you, Judge President.
Thank you very much. No further questions, CJ.
Thank you, Judge President. MEC Gade, if you have questions for the candidate, I now give you an opportunity to put your questions to him.
Thanks, Jay. No, I don't have a question. Let me plead you to proceed.
Thank you very much. Commissioner Ndolo Klepu.
Thank you, TCJ. Good evening, Advocate.
Good evening.
Thank you for confirming what I was thinking. I always believed in the issue of deviling, to say that you are actually not empowering. You are actually they become your clerks. So at least you have confirmed it. I'm quite happy that it's out there, you know.
Yes. I remember from one of the other interviews you referred to training. Well, training is a starting point only. the ultimate goal must always be to establish a sustainable practice for a new junior, and particularly the black juniors who have joined our society.
Thank you. Commissioner Mpofu.
Thank you. Good evening.
Good evening, Commissioner Mpofu.
Thank you very much. I just wanted to firstly, let me start with the positive one. I'm very impressed by the fact that you refer to the places by their real name, unlike your JP. You talk about Kabeja and Makanda, even in your document.
I must, in support
I'm wondering where this JP says he started something in Port Elizabeth. So where is that?
but in his defence, the Act hasn't been amended, so it's still the Grahamstown High Court and the Port Elizabeth High Court, according to the
I know,
Act.
but that didn't stop you from changing your letterhead to Kabeja. Thank you. No, I wanted to the issue I wanted to raise with you was the same question I asked the previous candidate. I see that you are turning 65 next Tuesday.
Yes, that is.
And you are a Libran like me.
Oh,
so
well balanced people.
Thank you. Yeah, those are the best people. Yeah. So what do you say about that? Why should that not count against you? And I say that in the context of you giving the commission, so that if it arises during the deliberations, give us reasons, because everyone brings something different, would bring something different to the judiciary. So in other words, you say, well, I might be 65, I might only have X number of years to give as opposed to a 40-year-old candidate. However, this is what else I will bring, which might outweigh that factor.
Yes. I would bring to the position my considerable experience over 35 odd years in practice, either as an attorney or as an advocate. I must also point out that with regard to the division in which I seek appointment, we have recently lost to retirement or elevation some very experienced judges, and we will lose to retirement Judge Robertson, whose position is also advertised here. We also lost to retirement Judge Chetty in Kabeja. So there is to some extent an experience vacuum that has arisen, and I am ready to help to fill that vacuum. I don't want to be presumptuous that I could fill it all on my own. But you're talking about having, and furthermore, I think in July, mid-year next year, two judges of 25 years experience each will be retiring. So experience is, in my humble submission, is something that's going to be required on the Eastern Cape pension, and I feel that I could go some way to fill that vacuum, and I'm ready to give the 10 years that remain for me to do so, I recognise what the acting Chief Justice has said to other candidates. You know, you can get more out of somebody who's also experienced if he's available for another 15 or 20 years. But I do come with that experience, and throughout my career at the bar, and particularly of late, I've been heavily involved in mentoring, and the judge present in progressively developing our bench and seeking to achieve the transformation target in terms of the constitutional imperative, will be appointing many, for instance, many acting judges who will be of various levels of seniority, and whom I'd be very happy to assist the judge present in mentoring them in the future, so that they can ultimately take up positions on the bench in a permanent basis.
Thank you very much. No, I think that's a very good answer. So in other words, what you're saying is that it's no use having a bench of 25-year-olds. I'm exaggerating for effect. You also need to blend the youth which is needed with the experience. Yeah.
Yes, I agree with that.
Thank you.
Commissioner Mpofu.
Thank you, Commissioner Moiman.
Thank you, Acting Chief Justice. Good evening.
Good evening, Commissioner.
Thank you. In your questionnaire, page 15, 6.3.2 and point 3, you make reference to two areas there.
He might be struggling to hear you.
No, I do. I am able to hear.
But it's not on.
Yes.
Your mic is not on.
I'm bringing your attention to your questionnaire under 6.3.2.3, page 15 thereof. What I'm more interested in is probably your just a reflection on the role that you played in enforcing the responsibility of the Eastern Cape government to respect court orders, because you make reference to Jaiya and Kate cases. Both of them was against the social welfare department.
That is correct, Commissioner.
And you raise an issue around the role that you have played, but also isolating these cases as part of your flagship cases.
Yes,
Can you just probably give me a reflection on that? Give the Commission a reflection on that, because central to this case was the bravery of the court to force the head of the department and the MEC to respect court orders. Thank you.
yes. These cases must be seen against the background of the broad picture in that the MEC at that time was faced with masses and masses of litigation regarding it had become a cottage industry where an applicant would apply for a social grant. The 30-day period would pass, and on day 31 there would be an application served against the MEC, and the court was eventually almost becoming the agency to award social grants, which shouldn't have been the case. Over a period, the MEC was advised how to deal with these applications. I remember one day appearing in the Gqeberha Motion Court in 800 matters on one day. With 800 matters had to be postponed because I couldn't get instructions on 800 matters to deal with them in court. So that had to improve, and the defences were categorised, and the MEC was advised not to willy-nilly oppose these applications where applications had merit, where people qualified for social grants, to give them their social grants. And that is the background to these cases. And I'm proud to say that eventually I was invited to one of the social grant offices in Gqeberha, it was in New Brighton, where in the past people had to come to court to get their social grants, where I was able to walk through with a number of applicants for social grants where they got the social grant, for instance, a child support grant, on that day. They came there and we walked through the application, and half an hour later they had their grant. So that's how matters developed. The Jaiya judgment has to some extent been overtaken by judgments of the Constitutional Court, where the Constitutional Court has found that even in matters where judgments sound in money on a structured basis, you can have contempt proceedings, what they call civil contempt proceedings. So to that extent, but Jaiya established the principle that you couldn't just lock up the MEC for not paying somebody social grant, which was quite correct. The judgment there. The Kate judgment then developed on that. The Kate judgment by Judge Ronaansen was the progenitor of a judgment that he eventually gave in a matter which was unreported in the Eastern Cape, a full bench judgment of Birchall versus Birchall, and which was then ultimately adopted by the Constitutional Court. I can't remember the name of the judgment.
Thank you, Advocate. I'm happy with that reflection. I suspect that is what we call positive judicial activism.
Absolutely.
Thank you. Thank you, Acting Chief Justice.
Thank you very much. Commissioners on the virtual platform, is there anyone who has a question?
Thank you, AC.
Okay, no. Commissioner Barnett.
Good evening, Commissioner.
Thank you. Ronaansen, you did some interesting work, it seems, on a judgment. I'm referring to the Borchard and Duxbury matter, which deals with the DocuSign app.
Yes, I have received some academic criticism in respect of that judgment.
Well, this is the thing, one has those wonders and concerns when you read it and so on, but you go into certain authorities there. Question is has it not become time in South African law to take a serious look at this sort of easier entering of documents? One understands the safeguards that should be in for fraudulent transactions, that sort of thing. But I'm thinking about the frantic concerns that there were in the COVID time, for example, when during lockdown people wanted to execute wills, and it became quite a difficult thing to do, in the initial phases and so on. So just your comment on that generally and your experiences, and maybe also refer to those criticisms as well. Thank you.
Yes, well, the criticisms were that I was perceived to have allowed an electronic signature as constituting sufficient compliance with the Alienation of Land Act to establish the existence of a valid agreement for the sale of land. Now, that's not what I did, because it was not an it was never an electronic transaction, and electronic signatures are applied in electronic transactions for which the legislation makes all sorts of provision, and that provision includes verification of electronic signatures and the like, and builds in those safeguards. But electronic signatures are, in terms of the legislation, are specifically excluded when it comes to transactions for the sale of land. And to answer your question, then maybe it should be in fact extended, because it would make sense in a modern world and enhance commerce to allow electronic signatures even in sale of land transactions, which I would advocate. But one must bear in mind that our property registration system is recognized worldwide as one of the best, and that it is so good because it promotes certainty, and you don't want to have uncertainty. So certain safeguards will have to be established before those signatures will be allowed for transactions for sale in land.
Thank you very much. Thank you.
Does that answer your question, Commissioner?
Yes, thanks. No, we can talk long about it, but we're a bit limited for time. Thank you very much.
Thank you, Commissioner Barnett. Was there another commissioner who had a question on the virtual platform or not? No. Okay, thank you.
Thank you.
Thank you. Commissioner Slem.
Thank you, ACJ. I just want to make a follow-up question on what you just said, concerning that you said you were criticized by academics. Do you think it is important for judges to take care of, or to keep up to date with what academics write about their judgments?
Yes, absolutely, I agree with that, Commissioner. I must just add, when I say academic criticism, I think it might be more from the property lawyers lobby in their various publications that the criticisms came than academics, because I know that judgment might be perceived. Professor Glover's book from Rhodes, his book on he says that for sale of land there must be a wet signature. So a wet signature, something you sign with a pen, and I didn't agree with him on that. So that criticism might still be forthcoming, but I agree that very much so. The judiciary must have regard of academic writings on because and they offer very valuable assistance in formulating judgments. You will note that in that Duxbury judgment, one of the bases on which I found was a suggestion in the the law, a contract book written by primarily Stellenbosch academics, my alma mater. That wasn't the reason why, but they suggested that if you could eliminate fraud, there's no reason why you could not use something like the DocuSign app, which I found was constituted a signature for the purposes of the Alienation of Land Act.
Thank you very much.
Thank you. It looks like we have come to the end of this interview. Thank you very much, Mr. Ronaansen.
Thank you very much, Acting Chief Justice and Commissioners, for your patience.
Once again, thank you for having availed yourself.
Thank you, that is my honor.
But you are now excused.
Thank you very much.
Thank you.